Hello, this is Antonio Gangale. This is part 4. We're examining whether criminal misconduct by government actors transpired in the United States of America versus Union Cheese Company case. Further, whether there was willfully depriving of rights under the color of the law and conspiracy to deprive rights under the color of law. Additionally, whether the June 16th order, whether it is void. Parts 1, 2, and 3, we examined whether the declarations by John R. Marzilli of the named individuals were they materially false, untrue, misrepresented, and or inaccurate. Further, whether the Declaration of Phillip within the Plaintiff's Memorandum in opposition to Defendant's motion drop party, where they materially omitted multiple official records prepared by the FDA indicating that Annette M. Gangale's title was a secretary, and that they skew or misrepresent the named individuals knowingly. Further, we want to examine whether the FDA's zero tolerance policy in the processing area, while the FDA surveys reported 13% of the commercial raw milk supply has listeria mono, did it conflict with established federal law of the aging of cheese for 60 days, as well as the standards of identity of Swiss cheese, and does it deprive rights or privileges under the color of law? With that, whether the declaration of John R. Marzilli was it legally sufficient, was there sufficient information within that declaration to make a reasonable determination, and that goes into whether John R. or Joseph M. Madden's testimony regarding possible levels in the milk were they materially false by omitting that Union cheese method for uses a high temperature short time process. And lastly, we want to see if the FDA spokesperson publicly misrepresented the mandates imposed on Union, while their FDA's own compliance officer privately expressed in a June 22nd call with a milk co-op informing them that it was going to be virtually impossible to resume operations. Are those conflicting statements? The declarations were filed under 1746. Are there issues that they were willful? Was there reckless disregard of the statements and a conscious effort to avoid learning of the truth? Did they continuously avoid learning of the truths in this matter? So we'll jump to the June 16th order, which states Defendants, Union Cheese Company Corporation, and Dominic F. Gangale and Annette M. Gangale individuals and all their officers, directors, agents, representatives, employees, attorneys, heirs, assignees, successors, and any and all persons in active concert or participation with them are hereby permanently restrained and adjourned under provision 21 U.S. Code Section 332A from directly or indirectly causing the introduction or delivery or introduction into interstate commerce of any article of food. And it goes on to say, unless and until the defendants have established and implemented adequate methods, facilities, and controls for receiving, manufacturing, preparing, packaging, distributing, holding articles of food in the facility to ensure that articles of food are not contaminated with listeria mono bacteria, other pathogenic bacteria, or filth. Such methods, facilities, and controls shall specifically include, but not limited to, the following. And this was under threat of civil or criminal contempt. So you'll notice it says listeria mono, other pathogenic bacteria. Astonishingly, Code of Federal Regulation, there's bacteria estimates, and the milk should be tested for bacteria estimates. Is it nearly impossible to bring in milk that has zero bacteria? Let's go here. It says surveys by the FDA have established that about 12% of the ball raw milk contains listeria mono. So is this order, is it extremely oppressive? And this order had multiple pages of mandates. Some of them you'll see for a period of 1 year, food processing, in process, food contact surfaces. It would be on their discretion, in process. So you see how oppressive this order, again, this would be under civil or criminal contempt if the order was violated. You see, I believe there was You see the costs. It was at their discretion. Means you could have whatever amount of individuals they want, any mandates that they were wanting or desiring. Here you see contemporaneously forward analysis and sheets, so you would have to forward all these tests. So just the sampling of the incoming milk would appear to put you in a violation. And let's recall that within the order, they were testing raw milk or examining raw milk test records, doing inline samples, testing the raw milk silo, the surge tank, a piece of equipment that goes before the pasteurizer. So they're testing in-process production even before the stages of lethality. So it seems inconceivable that this order could be even rationally complied with. You also see the expert witnesses' testimony. Dairy products are a major vehicle for the transmission of the organism. So we know that it's within the commercial milk supply, and also it appears, I believe, in the footnote number 7, which referenced a case study that it showed that it was within the commercial milk supply. Further, he opined that anything that comes in contact with listeria mono can become contaminated. So it wasn't only listeria mono, it was other pathogenic bacteria. Basically, is the court describing that they wanted sterility. And then how do you explain the right to use raw milk and the standards of identity if you can use raw and it's in the commercial milk supply? Like, does it conflict with well-established law? Are they changing law? What exactly does this order do? Very confusing that it appears to be in an impossible order. Nazi Germany, the Gestapo power, a law was passed that gave the Gestapo unlimited powers to carry out its duties. So it was legal for the Gestapo to violate people's rights, arrest, torture, imprison, murder without any judicial interference. So the Gestapo was above the law. Does this order basically give the FDA their discretion and whatever mandates? And were they even possible? Did it conflict with federal law? And here, I mentioned that footnote number 7, it cites this, and you see analysts of raw milk in the Midwest show 13%. How did a judge create this order? Well, we received the order on June 19th. June 22nd was when a lot of things were happening. I received a call from a co-op out of New York, and he was trying to come to some resolution, calling, and there's a lot more to this. So there's a whole backstory to these conversations. Well, we'll go a little into detail. Apparently, after the call with me, he called after my call, he was calling the Food and Drug Administration and trying to come to some resolution. Now, on the phone with Milt, I explained the order and didn't think that we would agree to some of this stuff. It just didn't seem possible or logical to do. He was apparently calling them throughout the day. Late in the evening, he had called me and informing me of certain conversations they had, and this is part of what was said. You'll want to probably go in much more detail of what was said during those conversations. My understanding, or that what was conveyed to me, was that they explained things to Milt, and he had mentioned, what if I took full legal responsibility? And in response, apparently they said that no Gangale would run that facility, something to that effect, and if they did, they would have it shut down within the month, and it was going to be virtually impossible for us to resume Swiss cheese manufacturing operations. The compliance officer clearly understood, or it appears that they knew, that this order would be virtually impossible. So there was also news reports and things. I did an interview with the local news television report, and they got a response with the Cincinnati district, and on the broadcast they mentioned or stated that all we needed to do is do the necessary repairs, something to the effect of do the necessary repairs and teach the employees good food handling techniques, which I believe that's a complete inaccuracy and doesn't express the whole understanding or the issues of what that order actually required union to do. So the Eighth Amendment, that excessive bail shall not be required, nor excessive fines imposed, or cruel and unusual punishment inflicted. Is this order impossible, and would it be a cruel and unusual punishment? It appears that the order would be so oppressive, and from the statements by the FDA and what they implied during my conversations with Phil during the court-ordered inspection, and what appears to be expressed to Milt during that June 22nd call, that they wanted union to be shut down. Ultimately, we determined that we'd rather go out of business than comply with the court order to rid our operations of dangerous bacteria. And you'll notice it says rid the operations. On June 6, 1995, a close friend and employee died by suicide. It hit me really hard. He was around my age. We did a lot of things with the plant, with the improvements. There'd be sometimes I would ask to do special projects like regasketing the separator, gaskets the press, or just things. So there's a considerable amount of time that we spent, and this order was just a punch in the gut. It was a difficult thing for me, most especially I would say about 10 days, maybe a little over. Can't really recall all the events. John had stopped by after the supplemental order that we would not continue running. Now, John was slated to be the next second cheesemaker. There would be 2 shifts, so that was going to be his position. We were discussing kind of things of, it was an extremely hard order to grasp, like from our perspective. It just did not make much sense. Further, when you just even look at the order, and also we were in one of the highest concentrations of Swiss cheese manufacturing in the world. There were many other facilities. We were like one of 2 in the area that were USDA approved. We were really making great strides in things. So it was something that we couldn't quite understand how this judge came to the findings that they did. And it just didn't. It was a hard thing to try to understand and grasp. As I mentioned, USDA approval. During that conversation, we discussed things, him explaining certain things. So a couple of my friends had suggested that I write a book and tell my side of the story, or let his voice kind of be heard, or kind of explain things from our perspective. So I started, jotting things down. Gonna dedicate a book to John, or the people that just didn't have a say, or things that we question or didn't quite understand. So I started kind of jotting things down, preparing the book and whatnot. I spoke with some of the old employees, some that were actually working at this facility, and so I'd stop in once in a while and see things that were surprising to me. So I was really starting to decide to do the book. I was at the point where I was going to get to the conversation and really explain the order. So I was actually hunting for the June 6th order, the June 16th order, when I had came across the actual complaint in this case. And while I was just going through it, that's when I discovered the statements of fact and noticed the underlining stuff, and realized it appears that they named the wrong individuals, or there was complete misrepresenting of those individuals. And when I went over like all the conversations with the FDA, what was said, how things transpired, it appeared to me that this was not accidental, and it appeared to me that there was an intentional skewing or misrepresenting of individuals. For those familiar with the matter, I believe they would say it would be inconceivable, unconscionable, that I wasn't named or given notice in the case. I believe they'd probably say that I was probably the only individual with direct knowledge of many of these facts. And it was clear the FDA knew who I was, and from conversations, even parties that were not even within the facility had knowledge of who I was. So it was clear, it appeared that they intentionally skewed it, and I believe that there was issues of criminality within this. I was speaking with several attorneys, and many of them just did not even want to touch the case, didn't know quite what to do. I also had things that were going on. There was this arbitration case, that was some things. Wasn't sure what to do, what the strength of the case, all these things. And again, this was kind of early on. Didn't even, at that point, even have the full court docket, so I didn't even know what was filed. I was blind of what transpired in the case, so I didn't know what was even presented in the cases, so it was just a lot of unknown facts at that time. It was August 6th, this would have been 1995, so 4 years from John's death. Just a lot of things are going through my head, a lot of decisions that I was needing to make. I was really debating if I'd go through with the book, how I would do certain things, how other cases were going to turn out. So I was unable to sleep, and I'd gone for a bike ride to just try to clear my head. In the process of the ride, I alleged that an officer had ran me off the road, charged me with operating a motor vehicle under the influence. I believe it to be false. I believe that there was a lot of constitutional issues, which you can examine those issues within this YouTube. Most disturbing is that there's administrative license suspension actually that came from law enforcement. So they're actually orchestrating what appears to be a civil action and pronouncing judgment. This was while I was in custody bleeding after I asked for an attorney. So it's just inconceivable to me that something like this even occurs in the United States. And you'll see trial records and that it's verified that I requested an attorney, and they just continued and ignored it and took saying that I refused the test, which is interesting. If Miranda applies or what, once you request an attorney, are things supposed to stop? So they alleged that there was a refusal. Anyway, we'll later discover that many of the documents, or all of the documents, seem to be tampered with. So these are notarized documents, or documents carbon copy under the penalty of perjury, seem to be changed and whatnot. Within this case, there was then countless legal issues. There was countless conflicts of interests, I believe, and countless legal things. So that was really hindering finances, as well as I didn't have a driver's license for nearly 2 years. The public perception of things and my reputation and things. So trying to do things was really complicated. This is in a time of 1999, which was, I believe, still when dial-up. So things weren't on the internet to search or find things as easily as it is today. So ultimately, I had filed. I could not seem to find counsel for many of these things. I was concerned for constitutional rights or protecting those rights. One of the two here regarding union, it was a cease and assist. And are there issues that the case would actually void? And are there issues of habeas corpus relief or vacating it? Again, I didn't have the access to information and attorneys. Within the state case, we discovered the tampering, the falsification. There was issues of countless rules of criminal procedure. What was the probable cause determination? the crash report was gone. We have documents that are tampered with. We have an ALS that appears to be, you'll see paperwork that's filled in. And what's interesting is, if you examine this, the zeros are different. Well, you could clearly see that these are carbon copies. So these are notarized documents. So you wonder, how in the hell does a notarized document get changed? And then moreover so it's filled in, but you see whoever's filling it in, the zeros are different. And then the bigger question is this time. So what's interesting is the state was withholding countless discovery. And I believe we were on 2 years. It was after the appeal. I actually sued in Tuscarawas County Court under the Freedom of Information Sunshine Request Act to obtain records and stuff. And what's interesting is you'll see that this was not within the discovery, was not the numerous times I went to get information, they never released it. So here you'll see the time. And we'll get into all the times that there's discrepancies in the time. It's at 440, it shows 456 rather than 446. But anyway, look at the YouTube video. But anyway, so you see the time. So it would appear that somebody with knowledge of that, and if this was done through the Ohio Bureau of Motor Vehicles, that there would be 2 or more individuals, and how would they communicating, whatever. So there was a lot of legal issues that I believed were violating rights. So ultimately, I filed a petition within the Northern District Court, and this is the one that Judge Polster, it was a First Amendment petition, and they permanently adjourned me, you'll see here, from filing any new lawsuits or other documents with the court. So I was sanctioned for attempting to protect rights or address things. So you'll see here some case law regarding the First Amendment. There's numerous here. That every moment continuous certain amounts of flagrant, indefensible, continuing violation of the First Amendment. That's New York Times versus the United States. Established now First Amendment, even for minimal periods of time, unquestionably constitutes irreparable injury. So if there's irreparable injury to federally protected rights, is there right to immediately relief? Here, a more serious evil would result if officials could determine which matters can be extended. Authorizing adjournment of First Amendment rights without advance approval of an official imposes an unconstitutional restraint, since the person would have to clear future First Amendment rights in advance with a judge. There is no higher duty under the Constitution than the careful processing and adjudication of petitions or writs of habeas corpus, for in such proceedings that a person in custody charged with the error, neglect, or evil purpose has resulted in unlawful confinement and that he is deprived of his freedom contrary to law. So in all these legal issues, the state's imposing oppressions, misrepresenting facts, was there issues of unconstitutionally held. Further, was were these cases, were they improperly done, would they be void? So they're putting void cases in things. So was there numerous legal issues within the state case? And if the court refused to file, or the judge refused to rule on certain things, or impeding that, were rights being violated? So with regard to the federal court permanently barring me, was there notice, was there a right to be heard before they issued the order? Are there issues with this impeding my access to the court? And is there oaths of justice that faithfully, impartially discharge and perform all the duties? So is there the duty for me, the right to be heard? Here, depriving rights under the color of law. Section 242, Title 18, makes it a crime for any person acting under the color of law or any law, color of any law, to willfully deprive a person of a right or privilege protected by the Constitution or the laws of the United States. Were there issues of depriving of rights under the color of law? And if local law enforcement or BCI or FBI or whatever choose not to enforce or don't want to pick up cases, does it mean that there isn't probable cause crimes had occurred? Can you go to a court and file those with the court? and who's the primary enforcers of laws in the United States. So is that a right that is provided to the people? If you impede the access to the courts, does that deprive rights under the call for law as well? In the early days of the Republic, a prosecutor was simply anyone who voluntarily went before a grand jury with a complaint. So is it still possible that anyone can go before a court with a complaint? There are no other rights if you cannot defend them. Where there is a legal right, there is a remedy. Fundamental principle: the right to sue and defend in courts is the alternative to force, one of the highest and most essential privileges of citizenship. In blocking access to the court, is it cruel and unusual punishment? So what becomes extremely concerning, so I was barred access, I believe it was 4/18/2001. It appears on April 13th, 2006, there was a third-party motion to vacate filed by, it says, all the defendants. I'm not sure if that's all totally correct. You'll see there was a motion of Guggisberg Cheese, Inc. to vacate the injunction. Here what's interesting, it says the grounds that the prerequisite was set forth by this court and its findings of fact and conclusions of law filed on June 16, 1995 said injunctions terminated would have been met. I'm not sure. I believe that that order was not possible, so I don't know how you meet all those conditions. Well, that's my perspective. The FDA's own compliance officer stated it was going to be virtually impossible to resume Swiss cheese operations. You'll remember that they wanted zero listeria and other pathogens. You recall that they were testing inline products, raw materials, the raw silo. They were examining raw milk test records, the balance tank or the surge tank before the pasteurizer. If you were doing extensive testing, it would seem inconceivable that you would not come up with a positive test. It would seem that you would, and particularly if you're examining all the records, because you are required by law or policy. I believe each producer is 1 or 2 bi-monthly bacteria tests, and I believe it also determines the cost of a component of the pricing of their milk. So I've never experienced that they have zero. There'd be some under a certain limit. However, to have zero bacteria is inconceivable to me. So I'm not sure how the things were complied with. Here's the letter. And what's notable, it says ingredient, and it states raw milk. And things with the facility, what's intriguing, disputes that we were having with the Food and Drug Administration and the events that transpired on December 14th and what those mandates that the FDA required union were expecting of us. So when you go through those mandates or perceive what they were imposing on union, it seems interesting, the difference in requirements from the same facility, however, different individuals. So are there issues that they conspired to deprive against rights? Are the declarations that they put forward, are they true and correct? The declarations of Phillip, is it true and correct, the truth, the whole truth? Was there ability to obtain knowledge? So was there ability to do searches? Was there court-ordered inspection for 3 days? The ability for discovery, the depositions and whatnot? It's clearly that they had an ability to know facts, and it's clear, I believe, that they knew facts from the totality of things. So did they materially misrepresent individuals, and would it have been criminal? And then if it's criminal and they were misrepresenting facts, is who all knew the information, what they should have known, A good tree cannot produce bad fruit, and a bad tree cannot produce good fruit. So every tree that does not produce good fruit is chopped down and thrown into the fire. How many people presented false, misleading, or inaccurate information before the court? I had received correspondence from the Justice Department when Guggisberg was filing. I was getting letters, or I believe this one letter, I was permanently barred access from the court. Think of what the court knew within the answer to complaint, the motion to drop party, even mentioning me within the June 16th order. So clearly they knew I existed. Court order seems to be impossible and conflicts with federal law. Issues, I think that I'm not sure that this is a fair and impartial venue. You want to go further is that the then being permanently barred access without the right to be heard, I believe that just is an egregious act, particularly when countless litigations and things of how does someone protect his rights if you can't go into court. When Guggisberg filed this in 2006, I barred access to the courts. Judge shall be patient, dignified, and courteous to litigants, jurors, witnesses, lawyers, and other whom the judges deals in their official capacity. Subject matter jurisdiction is defined as the power of a court to adjudicate a particular type of matter and provide the remedy demanded. Cannot waive subject matter jurisdiction, may be raised at any point in the litigation proceedings, even if the party had previously agreed the subject matter jurisdiction existed. They cannot waive subject matter jurisdiction. Are the issues that they improperly named individuals in the case? Would I be entitled to relief in this matter? Most interesting is that I will receive a juror summons from the Tuscarawas County Court. So within the juror questionnaire, it is to name the cases that I've been involved in. So I was doing searches with that court, the municipal court, and the federal courts. I'll notice that I was named as an interested party in 2006, apparently when Guggisberg started these filings. So unknowing to me that they put me as an interested party. So there was never notification to me that I could file or anything of that sort. You'd think the court that rendered permanently barring me would have discussed the possibilities that he would be an interested party in an action, or that this could have been a possibility. Also, informing me of things within the court. So I believe that there's issues with regard to that. I believe that there's legal issues of being able to vacate, or that this order is void. I believe there's right of habeas corpus, issues of subject matter jurisdiction, and just a numerous amounts of legal issues in this case. So I was attempting to just compile the trial record. I still don't have a full record of what transpired in this case. I did attempt to obtain the judgment, and unfortunately the document can't be found, so I'd really like to see what the particulars state in there. Recently, Jim Jordan made a comment. Apparently, the FBI have attempting to plant sources and whatnot in religious churches. He makes a statement: must be free to exercise their fundamental First Amendment right without worrying. They may have placed tripwires in their houses of worship. I believe that depriving them the right to file and then subjecting them to punished accordingly or whatnot, that any little detail could cause them to be held in contempt or even imprisoned in a place where justice is supposed to occur. I believe it's extremely troubling that I would be barred access to the courts, particularly when there was so much legal issues going on, and the issues of depriving of rights and willful depriving of rights. So I believe that there was criminal misconduct by government actors in the case. I believe that there was willful depriving of rights under the color law, and they conspired to deprive rights under the color law. I believe that the June 16th order and or the June 26th judgment is void in this case, and I believe I'm entitled to relief. I want to thank you for your time.